Let's talk about the children data entry fields. How many children means how many children age 18 or under that you have with your partner. A child aged 19 qualifies if still in high school. If you adopted a child belonging to your partner, you would include that child. If any of your children are under age 19 and out of the house, living on their own, they would not be included. Next, let's look at extraordinary visitation. If the non-custodial parent will have more than 127 overnight visits during the year, you would click the down arrow and select the range of days per year. Every other weekend, holiday and 2 weeks in the summer will not reach the 127-day threshold. Please try to agree on a visitation schedule, then count the number of overnights. Being with the non-custodial parent from 5 p.m. to 9 p.m. is not an overnight. Now let's talk about custody. The rules concerning custody and placement of the children apply to parties whether they are married or not. The word custody concerns where the child actually resides. This is called physical custody. Custody also identifies which parent will make most of the decisions about the child. This is known as legal custody. Joint legal custody means both parents have a right to help make decisions about the child. These decisions include education, medical care, legal status, activities, religious instruction, and other matters. Iowa law favors joint legal custody. Another custody option is known as sole legal custody. This means that one parent has the right to make decisions about the child. You would have to convince the court it would be better for the child to have one parent making the decisions concerning the child. This would require the court to say that there is clear and convincing evidence that joint custody is unreasonable. That it would not be in the best interest of the child. An example might be when one of the parents is incarcerated and unlikely to be released any time soon. You will see in the children data screen an option to check a box for shared physical care. Shared physical care is when the parents share equal time with the children. An example is when the children stay with mom for a week then stay with dad for a week. The parents work together for the good of their children. The parents make joint decisions as to what is best for the children. Shared physical care may not work if the parents live so far apart that it would work a hardship on the children. They must attend one school. If one of the parents would have to drive them 30 miles to and from school, perhaps shared physical care will not work. If you elect shared care and one of the parents does not take the children for their share of the time, the other parent may go back to court and ask that the decree be modified. If you think shared care will work, be prepared to explain what the plan with the children will be. Qualified additional dependent deductions are discussed in another YouTube video. See links in the notes below. If you are confused or struggling to get the information entered correctly, you will need to contact an attorney to assist you. Iowa judges, court staff and staff in the Clerk of Court office are not allowed to provide you with legal advice. They will not answer your questions. Visit iowasupportmaster.com and click on the link Unbundled Lawyers. Unbundled Services lawyers will charge you a small fee to prepare the Form 1 required by the court. Additional information and links are provided in the description below. Thank you.